This is Paul. Now, you know, Oyer, see Commission of Oyer and Terminaire. Um, this is kind of an interesting concept, and I think that a lot of people are really going to see a criminal trial held under a commission of Oyer and Terminaire. Old French to hear. Commission of Oyer and Terminaire. The reading in open court of a document, especially a deed that is demanded by one party and read by the other. Common law pleading a prayer to the court by a party opposing a profert, asking to have the instrument on which the opponent relies read aloud. Oyer can be demanded only when a profert has been properly made, but it is disallowed for private writing under seal. Cases, bill and notes, pleadings, letters of credit. Now, let's say that I never got notice of court hearings. Right. I didn't get notice of the court hearing on August 12th of 2011. I was a resident of Guam and there was no legal separation. I did get notice by minute order while being named as a defendant, but that would have been self-incriminating for me to appear in court without the actual verdict of the jury. Could have been used against me in a court of law. I did have the sheriff's department serve me, and it was put in mail and publication where the public notice included no less than, 13 or 14 civil rights violating court hearings. Yeah. And then you said that you served me in 2015, but you didn't. You attempted service, of me. Yep. But the individual that served me in the Sequim Public Library made sure that all the library patrons did know. Then you serve somebody other than the respondent, and I don't know the identity of that individual. Yes, and you attempted to serve somebody other than myself. Now, for all of this talk about me wanting something, Pooch, I'd like my wife to appear in court and read the protection order. Pooch, the one that was issued in 2011 that Judge Ken Williams issued. Yes, when I was in Guam and I was being accused of family violence, child support, or family violence, domestic family violence, child abuse, and assault. See, somehow I don't think that you ever read, yes, exactly what was being signed. You didn't speak it in the court. Now, there's what's known as the prayer for relief in each and every lawsuit, where I pray that you go to prison and you give me all your assets. Pooch. And for every police department that has any knowledge of this legal separation and the abuse of the Domestic Violence Act of the state of Washington. Yeah. It's one thing to say that the individual committed a crime. It's another thing to punish the individual as the victim of the crime. It should be the opposite. You being victimized realize the victimization that you experienced, and your want to punish the perpetrator of the victimization should not make you a perpetrator of the want to victimize those that have perpetrated the crime. And it sounds confusing, but right now, you as a victim should not want to abuse the accused perpetrator of domestic violence by teaching them the lesson that they're going to pay for the rest of their lives for the abuse that you experienced. Now, for the court to not read these protection orders, I don't think anybody read them to me. I did read them, and I did inform the court. Yes. Now, the thought that you can just fabricate evidence, Phil Donahue, pouch right now. The thought that you can use a two-count criminal complaint without any statement from me other than I wasn't there. The thought that the Domestic Violence Act of the state of Washington, its intent and purpose right now is to not make sure that the individual gets any due process before issuing a wage garnishment. Auburn Solis Marshall. Now, it'll be interesting to see of all the civil protection orders that have been issued in each and every state, how many of the individuals that said that they were the victim of domestic violence did get a did get a wage garnishment or account garnishment? Because legal separation is or is not a requirement of the issuance of any protection. I know that there's probably 10 to 15% of all protection orders that could be used to abuse the accused perpetrator. And for any individual that's ever been accused of that, you had an argument one night. I'm going to call the police. And you're the man and you're the aggressor, and 85% of all the victims of domestic violence are actual women. 15% are men. For some reason, I didn't think about calling the police when my wife hit me. But of all the wage garnishment orders, how many of them are men? Now, I would say if it's 85%, it's probably 85% of men are actually paying for wage garnishment. And it could be gender specific. It could be discriminatory to men. Yes. To intentionally take the word of men right now. Class action. Yeah. Little Missy. Excuse me, Missy. I know. It's Clallam County. Excuse me, Missy. I know. I know she went through a lot. She accused me of 14 misdemeanors, and the only thing I actually did do was call her CUNT. I didn't even grab her arm. I grabbed her hand. But I'm paying $18,000 a year for the next 25 years right now. Total of 33 years at $18,000 a year without any due process, without any legal representation. All because of being accused of domestic violence, child abuse, and assault. Without any due process, without any protections to my income, without any rights to my sons. Yeah. It just seems that once in a while now, when she appears in court and starts crying in front of the judge, she just believes everything she says. And I'm going to renew this for a year, okay? Because I know he got arrested. We served him the dissolution of marriage, and we put him in the slammer. And he got out. And he's on personal recognizance. But he's going to pay. He's going to pay.